all, and welcome to the next episode of the Partners in Crime Speed Mooting Podcast. In this episode, John and I dive into a mix of very exciting topics, including the hot news about a Legally Blonde prequel on the way. We also share updates on the Advocacy Club, where recently our members got to tackle an application to set aside a default judgment as part of our civil submissions meeting. Break this down for you, explaining what this application is and giving you some hints and tips on how it's performed. We also answer lots of questions that were put to us at this month's Advocacy Club meeting. And the episode continues with a general Q&A, so thank you for everyone for sending in your questions. So tune in to this week's episode for some legal insights, tips on legal advocacy, and plenty of speed mooting behind the scenes insights. Welcome to the podcast.
We are live. Welcome to the podcast.
Hi everyone.
Hello and welcome to the Speed Mooting Partners in Crime podcast. I'm John.
And I'm Hayley.
And this is our podcast where we talk about everything speed mooting, everything law, and everything else, quite frankly.
Everything in between.
Everything in between. So
it's good to be back.
It is good to be back. It's a while since we've done a proper episode.
Yes.
I've been caught up in a trial that's been very interesting, but very demanding as well, if I put it that way. It's been non-stop work for me, hasn't it?
Yes, and I've been holding down the fort as much as possible with speed mooting, so please forgive us. We did bring you a podcast every single week. They might have been very short, but we brought them for you. We didn't let up, but today we are back with a full episode for you all.
Yeah, normal service resumed.
We are excited.
And I suppose normal things are returning, but we've got one new thing today, in that, Hayley, you are going to name the episode today.
I'm going to name the episode.
Reason being, I've looked, there's never been a Formula 1 driver with the number 48, or not on the current system anyway. I did a quick search on athletes. They might be famous people, but I didn't recognise anyone with number 48. And we've found someone who's very, very, very appropriate. So I'm going to hand over to you, Hayley.
Okay, episode 48, we have a legend. She is an actress, but she's being named for a very prestigious role that she played.
Mm-hmm.
And it is Reese Witherspoon.
Reese Witherspoon.
Who I'm sure you will all know played Elle Woods in Legally Blonde.
Mm.
The reason that I first wanted to become a lawyer was when I watched that film, not ashamed to say. And I'm sure there's many, many people, particularly girls, that will be able to say the same thing.
Yeah, no doubt.
Yep. And it's very exciting for all of us Legally Blonde fans because it's been announced, and in fact I saw this on Reese Witherspoon's TikTok. They're doing a prequel of Elle Woods, and they've just recast Elle Woods.
Oh, brilliant.
And if you've not watched that TikTok, you need to, because it is perfect casting.
Wow.
The two of them together. So Reese tells, I can't remember the girl's name, but tells her she's got the part, and they're like, yay, hugging, and you would think they were mother and daughter. It's perfect.
Wow, that's crazy, isn't it?
Yes. So welcome to episode 48, the Reese Witherspoon special.
Welcome along.
Welcome.
So where did we start, Hayley? It's that long since we've done a proper episode. I can't remember what we do.
Well, I think, given that we've only done short episodes for a few weeks and we have quite a big backlog of Ask Speed Squad questions, we will use today to catch up on them all.
Absolutely, let's do it.
And that will probably be a meaty episode for everybody.
I think so.
Let's recap what happened yesterday evening, because that's going to lead us into a lot of our questions, John.
Okay, so last night we had our Legal Advocacy Club session. So if you're new here, we run a thing called the Advocacy Club. It meets twice a month and allows anyone, and we literally mean anyone, whether you've not started your studies yet, whether you're in your legal studies, whether you've graduated, whether you're in practice, it doesn't matter. Whoever you are welcome to join the Advocacy Club. And the idea of it is we have a different form of advocacy each and every month. So we cover a different form of legal advocacy. We also have sessions on public speaking and debating. And it gives members the chance to practice these pieces of advocacy in a very low pressure environment. We give you everything, there's no research, no drafting, so it's literally, here's all the papers, prepare your submissions, come along, practice, and you share feedback in a peer-to-peer environment.
Yep.
It's amazing how quickly people come on in terms of their confidence and their advocacy performance. Mm-hmm.
Oh, it really is. And we let our members come and just observe if they want to. So maybe people join, they're a little bit nervous, or they've had a demanding week at university, at work, whatever it might be. We say, it doesn't matter, still come along, you can just watch the session and you learn lots by osmosis that way.
You certainly do.
And lots of people think, oh, maybe I'll be an observer for months and months. And we've had some people, haven't we, that have joined and they say out loud, oh, I'm just going to observe today, I feel really nervous. And then someone else will pipe up and go, oh, just have a go, honestly, it's fine. And they go, oh, okay then. Because it's such a supportive environment that there's no judgment whatsoever. So you can come and have not done very much prep at all, and you can still just have a go. Even if you get a minute in and go, oh, I can't do any more. People are like, great, fine, okay.
That's a minute more advocacy than you did otherwise, isn't it?
Yeah, exactly. So it's...
So the reason... Sorry, it wasn't a ramble about Advocacy Club. The reason we're talking
about this... It's always good to talk about it, though.
It's always good to talk about. So last night, we had our civil submission session. So as I was telling the group, I picked a problem that... or a type of advocacy that you're likely to encounter very early on in your practice. So whether you're paralegal, county court advocate, pupil barrister, junior barrister, trainee solicitor, you're likely to encounter this form of advocacy, and it's the application to set aside default judgments.
Yes.
So our members got to tackle this piece of advocacy.
Should we give people a very little brief overrun of what that is, just in case someone's very new?
So just in case you're wondering what is that. Okay, so when people sue each other, it could be anything. It could be you've had a car crash, you're suing the person that went into the back of you, or it could be that you say there's been breach of contract and you're suing someone for £20 million.
Yeah.
Regardless, that is what we call civil litigation, isn't it, Hayley?
Yes.
And it's not like suits where you go, oh, you didn't pay up. Right, I'll see you in court tomorrow. Right, we're getting a listed. If
only.
No, you have what's called the civil procedure rules. So I'm not going to take your from that. I'm going to give a 30-second overview of this.
Yes, just so people can follow what we're talking about.
You get solicitors, they get solicitors. They correspond with each other. This is very, 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 very simple terms. They correspond with each other. Hopefully you settle. Sometimes you don't. Both parties say, I'm not in the wrong, I'm not in the wrong. So you obviously got to go to court. So that's when you have to follow you obviously follow in pre-action protocol. You then follow the
civil
procedure rules. So whoever's suing the other will say what's called a claim form. In simple form terms, a document that says this is why I'm suing you, along with the particulars of claim. The defendant's solicitors then have a certain period of time to A, acknowledge, and then B, serve their defence, which is a written document setting out what their defence is.
Yep.
If that set isn't served within the time frame, I think is it 28 days, Hayley?
Yes.
Yeah. Then if that defence isn't served within 28 days, the claimant can say, well, you've not filed your defence in time, I'm going to write to the court and say we get judgment in default judgments, which basically means you win automatically by default.
Yes.
As the name suggests, because the other side didn't respond in that time period. When the defendant solicitors then find out, oh no, the other party have filed for default judgment, you can then file an application to set aside default judgment, and then that will go to a court hearing, and you need to persuade the court to set aside this default judgment and let you continue with the claim.
Yeah.
So it's set out by parts of the civil procedure rules. So I think it's part 12 sets out the procedure for applying for default judgment. Yeah. And then part 13 sets out the procedure for setting aside default judgment.
I was just about to say, no, it's part 13, John, but yeah.
I remember my civil classes. So part 13.3 specifically sets out the test.
Yes.
So in simple terms, number one, you've got to show that you've got a real prospect of successfully defending the claim.
Mm-hmm.
There's been a number of cases that have analysed what does that mean. In very simple terms, you haven't got to show, it's not a trial within a trial. You've not got to show, on the balance of probabilities, we're going to win. You've just got to show that your case is more than merely arguable.
Yeah.
I.e., you're not just going, oh, this is something we're going to have a go on.
No.
This is something in law. You know, it might be, in this case, it was an issue over offer and acceptance. The defendant was saying, well, look, we gave this bottle of whiskey in lieu of, you know, payment price, whatever. That's bridged the gap. Therefore, there was the offer and acceptance, whatever it might be. And they're saying, well, you know, in law, that's a proper defence. We can argue that. You then move on to step 2, and these are alternatives, so you've only got to show the court one or the other. So step 2 is you need to show there's some other good reason for setting aside the claim. And in this particular case, the reason the judgment or the defence wasn't served in time was that the solicitor wanted to have a conference with the client before drafting the defence. That email to the client went into their junk. The solicitor then went on holiday, and the solicitor had set a number of reminders on the case management system as to, to say, you know, chase the client, let's get the conference, let's get the defence drafted. There was a glitch and these reminders didn't come up.
Yeah.
So they, taken together, they are all the good reasons why. And then finally, there's an overall consideration for the court, which is the need to look at promptness.
Yeah.
And in our particular case, the solicitor applies to set aside within 6 days of the court serving the default judgment.
Yeah.
And once again, there's a series of case law that considers what is prompt, what isn't prompt.
Mm-hmm.
But now there's an additional
there certainly
spanner
is.
in the works, as it were.
Good old Denton and White.
Good old Denton and White. So now, because technically default judgment is, or the Court of Appeal has said, because default judgment is technically, or was it the High Court?
I think it was Court of Appeal.
Was it?
Should we double check?
Yeah, so we're looking for the case of FXF and Karate Federation. There we go. You're like my, what does Joe Rogan say on the podcast? He goes, hey, bring that up. What's his assistant called?
His glamorous assistant.
Yeah. Jamie. Hey, Jamie, bring that up. I think it's Jamie.
Well, it is the Court of Appeal.
I thought it was, yeah. So the Court of Appeal said, well, we consider that default judgment is a sanction, and therefore the court has to consider the principles in Denton and White.
Yeah.
So,
which is the leading case on relief from sanctions.
Yeah. So in effect, you have 3 considerations for a Denton and White case. Number 1, you have to consider whether the breach is serious or significant. Number 2, you then need to look at why did the breach occur.
Yeah.
And then number 3, the classic one, all the circumstances of the case. So in effect, you might get some overlap. So normally, when you're looking at the breach, why the breach occurred, and then, you know, as in part 2 of your Denton test, and then part 2 of your 13.3 test, which is any other good reason, you might get some overlap in the two. But in effect, the court has to consider that. So, in a nutshell, that's default judgment for you.
Boom.
But yeah, quite an interesting problem to argue, wasn't it?
And we had a really, really good turnout at the club. So obviously everyone is really passionate to learn about this piece of advocacy. And as a consequence, we had a lot of great questions. So the structure of the Advocacy Club, did you cover this before, or I'll just cover it very quickly?
I can't remember. Let's talk about it.
So everyone practices the advocacy, then they get some general feedback from John, and then they get a chance to ask questions.
Yeah.
So the question part at the end, we have about 10 minutes, 15 minutes.
Yeah.
And we got so many questions that we said, okay, we're going to take these all offline. We'll answer them on the podcast. So everybody make sure you tune in on Friday, and we will answer all of your questions there.
Definitely.
We've also got some other questions that have been sent in to us.
Yeah.
Hence the reason why this is going to be an Ask Speed Squad special. Oh, you know, I've started creating like a little blooper folder for us.
Oh, that'll be good. Should we release it at Christmas?
Yes, let's do it. You got that to look forward to, guys.
Amazing, yeah. We'll have a blooper special.
Okay, so let's jump right into our questions.
Okay. So go on. What's the first one, Hayley?
Give me a second. Bring it up.
Yeah. Bring that one up, Jamie.
Okay. Could you refer to the Denton and White test in the intro of your submissions and use it as a framing device to show how each of the 3 submissions satisfy the stages of the test? I think this is probably getting at the fact that, as we've said, there is an overlap.
Yeah.
So whether they can use that to frame the other CPR points, I can't imagine that would come across very smoothly for the judge.
I think that might be difficult because ultimately with this is, whilst you've got to look at Denton and White, it's a very specific form of sanction with its own test to set it aside. So the way I went about it, and once again, I'm not a civil practitioner, so there might be a civil practitioner watching this that goes, "Oh, do you know what? If I was in practice, I would do it this way."
Yeah,
this
absolutely.
The way we covered it up within our bundle, we give a very generic skeleton argument just to give people a framework for their submissions. So within this, and this is a bare bones skelly.
Yeah.
Intro, we're applying to set aside under 13.3. Then, in effect, we have three headings. Ground 1, ground 2, ground 3. So ground 1 being whether there's a real prospect of success. 2, the other good reason. 3, promptness. And then we did ground 4, which effectively said now we're going to consider how the Denton principles apply. And, of course, there's going to be some overlap. Now, within your introduction, I suppose what this person is saying is, well, everything's going to be framed in terms of Denton. But I think, I don't know if what you're suggesting is trying to plug the 13.3 test into Denton. So what you're suggesting is go through the Denton and saying how this covers off the 13.3.
No.
I'm not saying it's wrong, but I just don't think that's the cleanest way to go about it, because ultimately it's the 13.3 test that the court needs to consider.
Yeah.
But the court also has to have consideration to the Denton principles.
Yes.
So what you would do is, I would still frame it, even within your introduction, saying I'm going to consider the test in 13.3, which is this, obviously, which I've just gone over. And then you could maybe, within each of your submissions, say how that complies with Denton, but I think it's cleaner just to then cover off Denton again at the end.
Yeah, I think so. And the reality is, this is obviously because this was from Advocacy Club, where your submission time is limited, you're trying to cram it all in, and suddenly you've got like another fourth ground to squeeze in. In reality, you'll have plenty of time. The judge isn't going to be rushing you. And if it is just repetition, which a lot of it will be, you'll just say, as I've covered off before, this principle in Denton and White, these are the circumstances, and the judge will just be like, yes, I'm with you.
Yeah.
It's going to be a lot easier in practice,
exactly,
isn't it?
In practice, because, it's the way you do submissions, particularly, for the purposes of the bar course, the SQ, etc. You sit there, you do your full submissions. In reality, you wouldn't go through all that. Normally, the judge will say, okay, I've seen your skeleton argument. I'm particularly concerned with why you submit this as a good reason. So forget all. I want you to deal with this first.
Mm-hmm.
So you'll start your submissions, and you'll find it'll just be questioning from the judge.
Yeah.
So that's probably how it'll go. So the judge will probably guide you with where their concerns are anyway. So it won't need to be as obviously you need a structure, because you might not get any questions from the judge. You might have the chance to go through. The last time I did a civil here, well, it was commercial within civil, wasn't it? And it was a video hearing, and the judge didn't really intervene at all. I had the chance to go through my submissions in full.
Yeah.
So yeah, that must have been interesting for him, having a criminal barrister on his this.
Yeah.
But
yeah, it's an interesting question, isn't it? Because there always is an element of creativity within advocacy, isn't there? So we're telling you, this is what we think, but other advocates might think, you know what? No, I would have done that in a really nice, smooth way. So there's no, for a lot of things, there's no one rule fits all, is there? So. It's interesting, and this is just our opinion on things like structure and things of that nature. But if you get all of the law in it and all of the legal tests, that it's not going to be wrong. Yeah. If it doesn't flow right, the judge just might not follow you as well as they could do. Precisely,
and this is just my opinion on this. There might be some civil barristers, solicitors, practitioners watching this who say, "Do you know what? I would rather go about it that way," and that's absolutely fine. And if so, please feel free to comment. I'm happy for you to do so and provide your opinion on this, because, as you say, Hayley, there isn't a one-size-fits-all approach with advocacy.
No. And this case was in, when was it, 2023?
The Court of Appeal case, 23, yeah.
So, in litigation terms, that's a very new case, so there'll be lots of people out there that haven't done it lots with the Denton test applied, or they'll just be, so it's probably emerging now how people actually tackle it.
Yeah, that's it, because I remember when we first brought in the app to set aside default judgments at the Advocacy Club, and it must have been around 2022-ish, and I remember I had this in the back of my mind, does Denton apply? So I did a bit of searching, And the general consensus was that there's just different approaches. Some judges say yes, it should apply. Some judges were saying no, it shouldn't.
Yeah.
So we took the approach initially of saying, well, to keep things simple, forget that. Whilst there's different approaches, forget Denton. But obviously, in light of this new Court of Appeal judgment, it's something you need to consider.
Yeah. It's always nice when something's clarified.
Oh, it is.
It's a pain in the backside when it's differing opinions.
Just wait until something goes to the Supreme Court and the Supreme Court say, no.
Not dead. No, scrap that. Okay, moving on. Okay, this is an interesting one.
Okay, go on.
So in older case law, so to give people a bit of context, one of the cases, because it was a contract law problem, was Folks and Beer.
Okay.
So that's from 1884.
Right.
So as you can imagine, this is the question. In old case law, the text uses kind of really old, archaic language. Is it acceptable to paraphrase rather than using direct quotes when it is in really old, tricky, archaic language like that?
Well, I suppose it depends, doesn't it? So if you were quoting directly from so let's say there's a specific line within that judgment that you think is helpful to you, and that might be the ratio of the case, there might be some obiter that you quoted. I would still quote it verbatim. Now, there's nothing to say. Let's say there's a word in there, I can't think, but let's say there's a word that's not really used now, and you might say, so quoting from Lord Justice Jones, I'm just making a judge of Lord Justice Jones, and it says, moving along, you quote this quote directly, and I'm trying to think of an archaic word that might not be used anymore. So you might say, well, for example, you read loads of old cases and it refers to lawyers as attorneys, and so you might say, it's fine. Any old example off the top of my head, and so you're reading this quote and you go, and the attorney, you might look up and go, Your Honour, I assume in today's language they would say solicitor.
Yeah. Look
back down and then continue with the quote. So if there's something in there that you think the judge might not understand, you can always look up and
clarify.
So for example, if ever I'm having legal arguments and I'm quoting from something and it refers, it's talking about something back, so I might say, once again, I'm just trying to think of an example off the top of my head here. The quote's just not entirely in context. If you're just looking at that quote, so let's say it's a contract case. So go and the contract was void for the reasons set out above, or for the reasons I've already stated, and you might look up and say the reason that the contract was void was because there was no consideration or something, and then continue with the quote. I'm just trying to think of something, so there's nothing to stop you looking up mid-quote to explain something in context, and then come back to it and then continue to read. Yeah. So that's what you might do.
Yeah, so if you're reading from a direct quote, you need to read the direct quote.
Yeah.
You can't, because otherwise the judge will be reading it along with you going, that's not what it says.
Yeah,
it will confuse them, wouldn't it? But if there's words in there that you think, that might not make sense, or that doesn't align
it's not
with...
in context.
It's not in context, then you can say, the table was brown, my lord, in this scenario, brown in those days was actually red, so the table would have been red.
Yeah, I get what you're saying, yeah.
Something like that, but yeah, you can't paraphrase if you tell them that you're quoting from a judgment. Yeah. You need to read it out.
Yeah, you're quoting. And once again, the judge in reality should be reading along with you, because hopefully, you've submitted all your authorities in advance, so the judge, your opponent, should have all of those authorities. Yeah. So when you're quoting directly from it, you want to make sure
everyone's reading along with you. Yeah.
Everyone's reading along with you. So I think I've said this before, but I'll repeat this for the benefit of those listening. You're going to be quoting directly from somewhere. You say, Your Honour, you'll find this at page 50 of the bundle, and I'm quoting from the third paragraph down, third line. Yeah. Has Your Honour got that? Yeah. Start reading.
Off you go. Yeah. Okay, hope that question and answer was helpful.
This video is brought to you by Speed Mooting. We are an organisation that help aspiring and junior lawyers. We run online and in-person advocacy and mooting competitions. We do online advocacy and public speaking training, and we run lots of other events to assist people on their legal journey. To learn more, visit our website, speedmooting.com. Next question, Hayley.
Next question. Could you make the argument that parties are free to agree agreement between themselves so long as it isn't greater than 28 days? Basically talking about you can agree an extension.
Yeah.
In this case, the claimant was very trigger happy to apply for default judgment. you can agree extensions. The claimant and the defendant between themselves can agree. Can you give me a little bit longer to file the defence, etc. But if there's no agreement being made,
no.
Let me tell you, in practice, we are trigger happy when we act for the claimants because it's great when you get a default judgment. So you ring in the court the day it's due, and if it's not being filed, you're not going to the defendant and saying, by the way, you haven't filed your defence. Do you want an extension?
Yeah.
You are putting in the default judgment right away. Why wouldn't you? It's you're winning the case for your client without going to trial.
Yeah.
So
And then on top of that, if they've then got to apply to set aside default judgments, and if it's granted, no doubt that's a cost order against.
Absolutely.
When you're talking about promptness, so on this case, so it's not even 6 business days, just 6 days afterwards. Mm-hmm. And you look at the case law, and I can't remember which way round it was. There's a case of Regency Rolls, which I think says 30 days was,
outside of 30 days isn't.
I think outside of 30 days you might suffer, and then I think there was a case of Khan, if I remember rightly, which says 59 days is at the upper limit. So you'd be saying to the court, well, look, when one considers the case law and what's been considered prompt in the past, we're well within that time scale. And you might take it one step further in your submissions and say, look, the civil procedure rules allow for 28-day extensions, to be agreed between the parties. And if a 28-day extension can be agreed, and that generally mustn't be seen as causing massive delay, if that can be agreed, we're well within that anyway. So I don't see how. Well, you don't say I don't see how, but you say, given that within that time period that can be agreed anyway, my submission is that no prejudice will be caused. Yeah.
So you can use the right that you can agree extensions up to 28 days to support your argument that it's prompt and it's reasonable to set it aside.
Yeah. I don't know whether I would make that argument, but you can certainly use it. There's nothing against it.
Well, yeah. But I don't think you could use it, which maybe I'm reading this wrong, but I think this is the way what the question is getting at. You couldn't use it to support your argument that the claimant shouldn't have applied for default judgment that quickly.
No.
In which case, it's not really fair that we're here because we could have just agreed an extension.
Yeah.
It's too late. Once you've got default judgment, you can't then say, but we could have had an extension. It's too late.
Yeah. Yeah, you can't blame the other side for applying for default judgment. Yeah.
No. I got many default judgments in my day. I never actually had to do. I either bring or defend an application to set aside default judgment.
I did one. I was the go-to guy on those sorts of things. So there'd be the head of the department would come around and go, oh, such and such a solicitor's missed this one. Can you draft an application for us, John? The number of times it was, John, we're out of time. Can you draft the particulars and draft a because you've got limitation, haven't you?
Yep.
And so I think it's section 11 of the Limitation Act, which gives you an extension to limitation. I can't remember what the test is for getting an extension, but they go, John, can you draft the particulars in a section 11 application?
Wow.
Yeah, so I was the go-to guy in.
I've never missed limitation ever, because I think especially being in the big firms, it's as soon as you get a case, what's the limitation, and it's flagged to the nth degree. So I've never missed limitation. I've ran to the court building with a claim form, said stamp this right now because limitation is today.
Yeah.
So we've come close. Anyway, let's move on. I think we've pretty much covered this one. How do we use the case of Denson and White without sounding repetitive?
Yeah, so as we say, it's not really a clean thing to do because you've got one test and then you've got to consider a separate test, but there's some overlap. So I think what you'd do is you'd say, once you've covered your 13.3 points, you go, I now wish to deal with the Denton and White point, which you'll need to consider, Mom. And you might say, well, you go through, so first stage is to consider whether the breach is serious or significant. You probably might not have covered that point, so you deal with that as much as you can. You then say your second point is the trying to think of
it's the breach itself, isn't it?
Yeah. So why did the breach occur?
Yeah.
So you say with regard to the second limb of Denton, which is why the breach occurred, I dealt with this in my submissions with regard to any other good reason. I don't wish to repeat those submissions unless there's any questions specifically that you have, Mom, and then they might have some questions for you.
Yeah.
So so that's how you deal with it without repeating yourself, and then lastly you go move on to the last part, which covers slightly other ground again.
Yeah. And even if you do, you know, it's okay to recap, and it's okay to go through things methodically, even if you think you are repeating some points.
Yeah, and I suppose what you might say is, just so you get another chance, another bite of the cherry, you might say, I'm not going to rehearse all of my submissions, save to say this is a matter whereby there was no malice and no fault on the part of the solicitor. Yeah. Most of this, you know, the reason for this breach is for reasons outside of his control. Yeah. But I won't rehearse all of my submissions. Yeah. Move on. You've made the point.
Mm-hmm. Yeah. So sometimes you do have to repeat yourself and be repetitive. It's okay, and the judge won't mind. They know you've got to cover all the points. So. Yeah. And they might even say, I'm with you, we've covered Denton and White. Yeah. I've seen it in your skeleton. They might not make you go through it all again. How do you say something is more than merely arguable? Do you refer to the evidence? This isn't a mini trial, right?
Yeah, well, exactly, that's it. It's not a mini trial. You're not going to have witnesses giving evidence. It's just you really providing commentary on the case itself. Yeah. So, with this particular case, so one of them is... In effect, I won't rehearse all the facts of the case, but it's a question about offer and acceptance and whether part payment of debt was sufficient to effectively deal with the contract. One party is saying, well, you know, we should have been given more money, etc. What you'd say in this is, well, these are the facts of the case. These are the, you know, I think it's undisputed what the facts were. So you say, look, these are the undisputed facts in relation to the case. It's our submission that the bottle of whiskey that was given bridges that gap, and that is consideration. This, you know, is a long-standing principle in contract law. This is a matter that we can put to the judge, and for the judge to consider at trial. This isn't a matter where we're having a go. Yeah. You know, we're hoping that the evidence is found in our favour. This is a properly arguable point. Yeah. It's a sound legal principle, and therefore this isn't something that's just a fanciful argument. And that, you know, you don't need to really go much beyond that. Yeah. So what you want to do is set out the facts that you rely upon, what the law is, and then go from there. Yeah, yeah. In most cases, because normally if something's going to go to trial, most parties have got an argument one way or the other. So I don't think it's often that you'd fall down on that point. Funnily enough, a few of the cases that consider this do fall down, even though there were cases that dealt with promptness, actually said that they do fall down on that point anyway. Yeah. But yeah, as long as you've got a point that, you know, you can say, well, look, this is a sound legal principle that we're going to rely upon. This is why we say we can defend the claim. Then yeah. Yep.
What would your advice be for preparing speaking notes to guide you through your submissions, especially when there's multiple bundles or cases to jump back and forth from?
Okay, so I mean, there's different approaches with this. You can, obviously you'll have your skeleton argument, which is the bare bones of what you're going to rely upon. You can prepare a full speech if you want to. You know, there's nothing wrong with that, as long as you practice multiple times alongside that, you know, so you're not going to be fully reliant upon that speech. Then, as you say, you know, you've got multiple documents, bundles, etc. So what I would say is, when you get to each point that you're going to need to refer to a section of the bundle, within that paragraph, put it in there, you know, just in brackets for yourself, where, you know, the case is, the quote is that you're going to rely upon, and have that tabbed up in the bundle. Yeah. Have it marked up. Obviously, if it's a digital bundle, you don't need to do that. You just need to jump to the relevant point. But when you've got a physical bundle there, have a tab there, so it's easy for you to jump to that part and mark the tab accordingly. So you might have, say there's going to be 5 sections of the bundles, have 5 different tabs in there. So let's say, you know, within paragraph 2, you know, you're going to need to, you know, the second paragraph of your written script, you know, you're going to need to go to page 20 of the bundle, mark on there, yellow tab, so you can cross-reference that across. Yeah. But ideally, you want it so you've practiced that many times that you simply can work off your skeleton arguments. Mm-hmm. So you know that you're going through and you can work off that. And the reason that's important is because you might find, if you're in a competition or something, you're going to get judicial intervention. When you get that judicial intervention, you know, they might be asking you to deal with a different point, jump around, so you can deal with that properly. Yeah. So the key thing is, you know, there's nothing wrong with having a script, but you need to make sure that you're practicing.
Definitely. This just made me think of, it is related, but I'm going to go off on a little bit of a tangent. So we're both members of Liverpool Speakers Club, aren't we, John? Yeah. And just this weekend, we went to the national conference?
District
The
conference.
district conference. So the Liverpool Speakers Club is part of the Association of Speakers Clubs. So there's clubs in most cities up and down the country, isn't there?
Yeah.
So we all get together and we do a district.
So you do a local club competition.
A local
to
club
determine who's the winner
competition.
in your club.
And then you go
You
on
then go to area.
Yep.
Then the top 2 from area in each contest go through to district.
Yep.
The winner in each category in district goes through to the national final.
There we go. Yeah. So it's various speech and public speaking technique competitions, isn't it? And for the speech competition, we watched some really good speeches this year. But there was 2 people in particular that were both had a script in different ways.
Yeah.
So one person had notes, like the script in front of them, and partway through they started saying something, they said, oh no, that's not right yet.
Yeah.
And went on to another bit. And another one, he'd obviously memorised it, but he was still reading from a script, like, in his brain.
In his head, yeah.
Because at one point he went, oh no. And then he got it back, didn't he?
Yeah.
And when we have feedback at the end, National President was giving feedback, so obviously he is like chef's kiss, public speaker, he knows everything.
No, he's good.
And he was saying, this is where the danger comes from having a script. You're so reliant upon it, even if you've memorised the script.
Yeah.
You trip up one word or you forget one sentence and you're lost. Where if you don't have a script or you just know the material well enough and you've just got a couple of bullet points or your skeleton argument, you know what you're going to talk about. You might not have every word rehearsed or every word memorised, but you know the material enough, you've got fluidity and you're an accomplished enough speaker that you can just make up a speech off the cuff. Yeah. It's a really difficult skill to master, isn't it?
Yeah.
But you would think someone that memorised the script, it would be perfect, but he still got stuck because he forgot like his next sentence.
Yeah.
So that's like another area of where having a script can be dangerous, which is really interesting that we've seen it.
It is though. It is interesting because that's what I used to do years ago when I first started, and I have a full script, and then you basically get to the point where you no longer need it, but you're remembering the trigger points in your mind, and it's like you can almost visualize the script in your brain.
Yeah.
And you need to get to the point where it's quite dynamic. You've practiced so many times, it's coming out differently each time.
Yeah.
So you just need to know the material that well.
And just have your little, like, your bullet points or your trigger points that this is the next point.
Yeah.
And it doesn't have to sound the same every time, or even if you do forget, it doesn't matter because you know that much of this material, you can just say something else.
Exactly.
Yeah. Okay, so this person has asked you to give a refresh of the process of introducing evidence.
The process of introducing evidence. Okay. So presumably this...
It says in a civil and a criminal context.
Okay, all right. So evidence can come in many forms. Strictly speaking, evidence comes from witnesses. So a witness goes into the witness box and they give their evidence. Now, in a criminal trial, a witness has to give full live evidence, both for evidence in chief and cross-examination. Okay, so normally they'll serve a witness statement in advance. Prosecution witnesses do. On the defence side, not always the defence witnesses give witness statements, and certainly a defendant doesn't have to. A defendant will normally produce what's called a proof of evidence, which is a confidential document between them and their solicitor, barrister, etc. So what happens is a witness is called, they go in the witness box, they either give their evidence on oath, so on their own particular religious book, or they will affirm their evidence. Their barrister will ask a series of questions, open questions for them to tell their story, that's called evidence in chief. The other barrister for the other side will cross-examine, and if there are multiple parties, multiple barristers can cross-examine. In a civil trial, it's a little bit simpler. Witness statements are served in advance. Mm-hmm. The witness gets called. Their barrister will say, get them to confirm their identity. They'll say, you drafted a witness statement on such and such a date. Yeah, is that your witness statement? Yeah. Is that your signature on there? Yeah. Did you read the statement of truth beforehand? Yeah. Are you happy with its contents? Yeah. Is there anything else you want to add? No. Well, sometimes you might say yeah. And then you say to the judge, I think this is how you go about it, may that statement stand as their evidence? Yeah. Sit down, then they get cross-examined.
Yeah.
Okay. Now, in terms of other, let's say there are exhibits, witnesses produce the exhibits. So, let's say it's a police officer and they've seized a knife. When you were at the scene, did you find anything? Oh yeah, I found the knife. Is this the knife that you found? Yeah. Your Honour, this will be Exhibit 1. Goes into evidence. Very straightforward.
Yep.
In a criminal trial, so I'll speak about crime, there's other ways that we can get things into evidence. Sometimes there might be, well, in most criminal trials we tend to have what we call a set of agreed facts, and that will normally be read by the prosecutor at the conclusion of the prosecution case. So it might be, I don't know, you might have some sort of agreement on the time of the arrest, you might have agreement in relation to, let's say there's bad character and there's bad character evidence that's going to go in, such and such was convicted of this offence on this date and received this sentence. So, you know, that's how it goes in. But long and short, if ever you want anything beyond, you know, the pure verbal evidence of somebody, you need exhibits, then a witness will produce those exhibits.
Yeah.
So yeah, fairly straightforward. I think the process in employment trials is slightly different because I think the witness literally reads their witness statement, if I remember rightly.
Oh.
Yeah, I think I've heard that.
We'll have to get an employment lawyer
Need
on.
to get an employment lawyer. I've never done any employment law, but I'm sure I've heard that. That's how it goes. But yeah, but that's how evidence is introduced at trial. It's very straightforward. Witnesses go in the witness box and give evidence, and if there are any exhibits, they produce them.
Boom. So we're moving on. I should say this isn't from the default judgment session anymore.
Default judgment now.
Yeah, which is why you're probably thinking it doesn't really make sense in the context of default judgment, but here we go. When we are in bar school, we're not taught much about adjournments.
Okay.
Could you explain these and why, when they are used?
Okay. So an adjournment is...
Let's give it very simple.
Yeah. So an adjournment is when you say, you know, a hearing isn't going to go ahead and we're going to kick it off into the long grass effectively. It could be anything. I'm saying that for a trial, you know, literally, technically, when you go to a first appearance, a case is then adjourned for however many months before the trial itself. But normally with an adjournment, and I'm talking about this in a criminal context, civil, same principles apply. So let's say you've got a trial that's listed for, I don't know, 20th of May, and the prosecution is due to serve all its evidence by 2 months before 20th of March. And then the prosecution, as may be the case, can't serve its evidence on time and says, oh, we're very sorry, we can't serve our evidence on time. So then they, well, should apply to the court in advance, normally on the day of trial. And so, no offence to the Crown Prosecution Service. Will say, oh, very sorry, we've not been able to serve this evidence on time. We need additional time. Please may we have an adjournment. Sometimes the defence might agree. Sometimes the defence might say, criminal procedure rules are there for a reason. We want to oppose the adjournment. And then you might have an argument about whether or not the case should or shouldn't be adjourned. Now, the principles used to be set out in a case of Picton, and there's a number of factors for the court to consider. You want to look at, so thinking off the top of my head here, I've not reminded myself of the principles, but long and short, you're looking at who's making the application. Is that party at fault? Have there been any previous adjournments? How has compliance been previously between the parties? What would the significance of an adjournment be? So, you know, how far away from the particular incident are we? Is it going to impact upon the memory of the witnesses? So a number of factors for the court to consider. And then the court will either say yay or nay on the adjournment. Sometimes it might be agreed. Sometimes, you know, one party might say to the other, do you know what, we're not going to get this evidence in time. Can we adjourn? I'm saying on the basis of evidence not being served. It might be a witness is unavailable. Mm-hmm. And if the application's made well in advance, you know, both parties might agree to it. But the closer you are to a trial, the more difficult it becomes. So particularly taking the example of a witness, you know, when the trial, let's say, you know, your trial is listed in 6 months' time, you know at the first appearance when the date of trial is. You should be warning all your witnesses at that point, and then you should find out very, very quickly if those witnesses are unavailable. Mm-hmm. If you're then finding out 2 weeks before the trial, oh, a witness is unavailable, the obvious question is, why haven't you done your homework properly? Why is it taking you so long to warn the witnesses? But, you know, typically evidence being served very, very, very late in proceedings.
Yeah.
I do a fair amount of motoring cases, and you get a lot of cases where evidence is served very late in the day. And it makes you question, actually, and this is maybe a debate for another day, but what are the point of directions in
Yeah.
So so this moves us on to another point, but this is a big difference in criminal and civil law. Civil law, you breach a direction,
Yeah, you've got to get relief from sanctions.
you need relief from sanctions. Criminal law, a party breaches a direction and it's, oh well,
Let's carry on.
let's crack on. So it makes you wonder, what
Yeah.
why do we even have the criminal procedure rules?
Yeah.
Answers on a postcard.
Yeah, I imagine the chances of getting an adjournment are higher in civil though compared to criminal.
Depends on who you judges. All depends on who you judges, really. So you get.
But I suppose the stakes are arguably lower, aren't they? Like it's usually just someone fighting over like a monetary claim or something. Where if you're the defendant and you're saying I need to deal with this today, I've been waiting for 6 months for this, or I can imagine a judge is more likely to be like, no, you know what, this isn't fair. We're going to deal with this today. Where in a civil, it's yeah, we can deal with this in a month's time. It's not
quite often, yeah. I mean, that's normally
the detriment is probably worse, isn't it? That's what I'm trying to say.
But and this is another factor, within the. I say in the case of Picton, it's contained within the criminal procedure rules now. And another one is the significance of the offence itself, its seriousness, and I think that you've raised a good point there, Hayley. I was being a bit flippant talking about the procedure rules, but what one of the factors is at the end of the day, this is a criminal offence. It needs to be dealt with, and sometimes the Crown might need that additional time. As I say, the Crown, sometimes it is the defence that make these applications, but that's something for them to consider. This is an allegation of a criminal offence, and they want to make sure these matters are prosecuted properly. So that's one factor for the court to take into account.
Yeah.
But yeah, I mean, it's like the approach to default judgment when it was unclear whether Denton applied. The approach in different courts across the country.
Yeah, very true.
All over the shop.
Yeah, very true. But in civil as well, it's you can argue like we're just gonna come back in a month, the detriment is low, and the party that needs the adjournment can be ordered to pay the costs. So it's, why not?
Yeah.
But I have still seen it where the judge just said, no, we're going ahead today.
Yeah.
We're not having an adjournment. So it does happen.
Yeah.
It does happen. And another closely related thing, which I think is not a thing in crime, is staying proceedings. Don't do that.
Explain what that means.
So when both parties will agree to stay the proceedings, to effectively pause the claim for a period of time, and it's usually to try and settle, to explore settlement.
So in effect, would you have no future date set, or would you have a?
Yeah, so it's usually right when you're doing your allocations, you'll both tick to say you're happy for there to be a stay, or you can apply to court and say we're making good progress, let's stay the proceedings. So before directions are set.
Oh, okay.
And then the stay either comes to an end, or you'll have directions that say this stay is in place until 26th of April. Either party must tell the court by on or before 26th of April if you need a further stay, if the claim's been settled, or if we need a case management hearing.
Yeah. No, there's not normally. You'll always have at least some date in the future for something, even if it's So, for example, you might have a case whereby, let's say you rock up at a trial, an issue's been set, and the prosecution go, oh, we might be able to, find some evidence that deals with that point one way or the other. Either it helps you, or it's going to, put the nail in the coffin for the... And so you go, well, we'll list it for a mention in 2 months' time. If this evidence comes to light, then, we'll deal with it there. We either set a trial date or we'll be pulling the plug, as it were. But you'll always have that date in mind. The closest thing I can think is lying on file, basically, which basically means that normally that's done when you agree some sort of basis of plea. So let's say there's like 3 counts on an indictment, and the prosecution say, well, we'll take a plea to count 1 and count 2 on a basis. They go, that's agreed, and then the prosecution say count 3 is to lie on the file. And that means it basically lies dormant. So technically, it could be revived in the future.
Yeah.
Normally it's not, But, it's rather than it being withdrawn, it's just there to lie on the fan. It just remains dormant
there we
eternity.
go. I hope that helped the person that was asking us about adjournments. Interesting, they don't teach that in bar school.
Yeah, I think it's because there's so much other things, so many other things to teach. But yeah, I mean, just for your purpose, an adjournment is literally just,
pausing the case.
Pausing the case, or you need to push it forward because for one reason or another. So it's dead simple, straightforward.
Yeah.
When you come to practice, you'll get used to dealing with them.
Yeah, and you'll be very used to at the 11th hour instructing solicitors, ask for an adjournment. Yep. Next question. So when your opponent is dealing with a series of points and you want to rebut them or jump in with your point of view, do you do that after each point, or do you wait until they're finished and then make your submissions that deal with everything they've just said?
Yeah, I would say let your opponent finish. Court is all about courtesy. Show courtesy to your opponent, show courtesy to the judge. I remember I went, this was years ago, back when I was a solicitor, and I was making an application, and the prosecutor just kept jumping up in the middle, and he just looked so odious doing it, and it didn't impress the judge at all.
Mm-hmm.
And I think I might have made a flippant comment about it, but it just made him look like an absolute tool.
Yeah.
Let your opponent finish their submissions. Unless the judge turns around and says, well, let me just pause you there. Mr. Dove, do you have anything to say? But yeah, let your opponent finish their submissions, and then you jump up and then you make yours. This is in the context of a legal argument, etc.
Mm-hmm.
Cutting your opponent off, or saying, well, they've made a point, let me respond to that. No, let them finish. You jump up, you make your submissions. That's why you'll make little notes for yourself as you go along, so you remind yourself to deal with certain points.
Yeah.
Cutting your opponent off, it just doesn't have the right look.
No.
Unless they've said something that's so wrong in law, or something that you feel but that's going to be few and far between.
Yes.
Let them finish. Show courtesy. Because you would expect the same courtesy when you're making your submissions. You don't want to be cut off mid-point.
No.
And you've always got your right of rebuttal, etc. So yeah, don't be cutting your opponents off mid submission. It's just not the right look.
Boom. Last question. I've saved this one to the end because it's a fun one.
Oh, go on.
On TV, you see barristers standing up, interjecting questions, shouting, "Objection!"
Yeah.
In reality, when do you actually do that?
Okay. So usually it's in relation to the questioning of witnesses. So we don't. We're a lot more sort of small c conservative in this country, so we don't stand up and go, "Objection!" It's. I remember the first time I ever objected to a question. So my client was in the witness box. Prosecution barrister asked him a question which, quite frankly, he couldn't answer. It's outside of his area of expertise. And I stood up and said, "I'm terribly sorry. I'm going to have to object to that question. I don't think that is a question that my client can rightly answer." And the judge said, "Yeah, fine, yeah, I agree." So we are a lot more reserved in the way that we do that.
Does it happen often when you have to object, or is it few and far between? Not often.
Some people do it more than others. I've co-defended with people and they're jumping up left, right and centre. But for the most part, professionals, we know where the lines are. We know the rules of evidence, so we know how we can question witnesses. And sometimes the judge cuts in as well. So sometimes you might ask a question, the judge goes, "No, that's not a question. No, you can't ask that." But yeah, we're a lot more reserved in the way in which we do that.
Mm-hmm.
Sometimes cuts both ways, so sometimes you might get cut off in evidence in chief and sometimes in cross-examination. So as you may or may not be aware, the general rule with evidence in chief is that it should be open questions, and you shouldn't be leading or you shouldn't be introducing a new fact that your client hasn't said yet. And you get some smarmy people that'll, and I say smarmy, it is what it is. I've never personally had this, but I've heard of it, where you might ask a leading question in evidence in chief and your opponent stands up and goes, "I'm terribly sorry, but does my learned friend want to go in the witness box? He appears to be giving evidence here."
Love it. So you're objecting, but in the most polite way ever.
Yeah. And then in cross-examination, I just say, if you asking questions that is outside the area of expertise, asking questions that shouldn't really be asked. You just stand up and say, I'm terribly sorry, but my client can't answer that question, or I'm terribly sorry, I'm going to have to object for this reason. So yeah, we're not as... I've never watched an American trial for real. I don't know whether the Americans do that with
I bet they do. They're so dramatic, aren't they?
Yeah.
So dramatic. We just finished watching the Beast Games, didn't we?
Oh, yeah.
With Mr. Beast.
Mr. Beast, yeah.
And it was a really good show. We'd recommend it. But my God, the Americans are so dramatic.
Aren't they just?
Everything is like...
I'm so sorry. Oh, I love you so much. Oh, no. You know,
you're in a game show. You're there to win.
I know, yeah, they've just eliminated someone and you're like, yeah, that's the whole purpose of it. Like in court, you win a trial and you go up and you hug your opponent. Oh, I'm so sorry. In tears.
Maybe they do in America. When we go to Texas, we're planning a trip to Texas this year. Maybe we should get ourselves into like a Texas courtroom and watch it.
That'd be interesting. Although, I imagine Texans aren't the way that we've seen with those sort of Americans.
Oh, I bet you they still are. Like,
do you reckon?
Not like emotional that way, but they will be dramatic.
Yeah.
I can't do a Texas accent, but objection, Your Honour.
Oh, yeah. Sorry, what I mean is, like, you know the way we watch people on Beast Games?
Oh, I know.
They're all crying and hugging and all that
But
kind
I bet
of
you
stuff.
the courtrooms in Texas are still
I think that'd be very cool.
interesting.
Yeah, we should try and get into a courtroom
We
in
should
Texas.
do, yeah.
There's a lawyer I want to meet up there, actually, the Texas Law Hawk. Google him. His adverts are brilliant.
Okay.
Yeah.
Try and set it up. Try and do a podcast with him when we're out there.
Oh my God, that'd be amazing. Texas Law Hawk, if you're watching, hit me up.
Yeah. And everyone watching, like, tag the Texas Law Hawk.
Yeah.
Like, what is this?
Yeah. You're like, what is this? I think he's in Fort Worth near Dallas. So.
Wow.
Yeah.
Anyway, they are all our questions.
They're all our questions. So that's been a long one.
Yes.
Longest one in a while. Hope you enjoy this. If you're on your commute, hopefully it's filled your full commute rather than getting 10 minutes in and going, I need to find something else to listen to.
And if there's any more burning questions that you hoped we were going to answer today and we didn't, you can always contact us. info@speedmooting.com is our email address. @speedmooting is our social media handle. You'll find us everywhere. You can comment, you can direct message, whatever you like, get in touch and we'll answer your questions next time.
Yeah, absolutely. So, I've certainly enjoyed this return to form. Have you enjoyed this one, Hayley?
I've enjoyed it, John.
And if you're still listening at this point, you are one of our real listeners. And I would say drop us a comment of Legally Blonde.
Legally Blonde, yes.
Yeah. Well, that's the end of the episode. Until next time, cheerio.
Bye. Enjoying our videos? Then we'd be super grateful if you could take a moment and subscribe to our channel.